Reasonable assurance. From this guy, the judge's face says it all. This parole decision might just be the most optimistic thing since the Titanic's maiden voyage.
I've received a copy of a parole board decision dated September 24th of this year. They intend to reinstate your parole this November. And they find, quote, reasonable assurance exists that the offender will not become a menace to society or to the public safety. I mean, I don't want to stray too far out of my lane and talk about the parole process, but come on. I could not disagree any more with that statement. I think it makes a mockery of the criminal justice system. I don't even know what words in the English language mean. If you can say those words about this offender at this time, reasonable assurance exists that Mr. Page will not be a menace to society or public safety. How about he drives?
Classic defense play. Highlight rehabilitation. Minimize risk. But the problem? Page's track record screams relapse, not recovery, and the judge knows it.
Drunk whether he's on probation or parole. How about he commits felony crimes even while he's in prison? I'd like to know what the parole board thinks is a menace to society. I think it might be Mr. Page.
What I think is most important to highlight today is that Mr. Page stands before you today ready, willing, and able to tackle his substance abuse issues. With the grace of this court, Mr. Page hopes that you'll allow him that opportunity. Mr. Page realizes that you've heard that before, and that those words are often hollow. He is sincere, and his actions since this last offense show that he's ready to start his journey towards recovery. The people closest to Mr. Page have also reported that his genuine efforts, that he's made genuine efforts at becoming a changed man. His conduct while he's been incarcerated has been exemplary. He's had no write-ups. He's engaged in the...
You can feel the desperation here. And honestly, who wouldn't sympathize? But here's the real question. How many last chances can justice afford before it stops being justice?
Services that are available to him in the jail. For long-term sobriety, this needs to continue. That's why we're asking for the jail sentence followed by inpatient rehab at KPEP and then followed by a term of probation with alcohol monitoring. Thank you, Your Honor.
Thank you, Ms. Elliott. Mr. Page, you don't have to say anything today, but it is allowed. Is there anything you want to tell me or no?
Yes, Your Honor, I do.
Okay, go ahead.
Your Honor, I did prepare a speech and I was going to give it today, but my lawyer took a copy and gave it to you so you may read on your behalf.
I already did.
Yes, Your Honor. I understand that people come in here every day and they try to explain to you that they're trying to get sober and they're trying to live their life better, but I really truly am. And I understand that my past does not reflect that whatsoever. But I truly am ready to quit. I've been going to AA every month or every Monday morning that I can, and I'm really just trying to get help. And I'm honestly so ready to get sober, and I want it and I need it. And I understand that there's a big lengthy prison sentence in front of me. And I've done 6 years in prison, Your Honor, and it just does not help me. I have a lot of trauma to deal with, and I really am ready to face and handle these problems. And, it's just, it's hard for me to sit here and convey to you who I am as a person because my past does not reflect a very good thing. And all I'm asking is, please, Your Honor, to just give me a crown a year and to offer me KPEP at the end of it and probation and the ankle monitoring. If I screw up, you can give me a lot of time. I know I'm facing that right now, and I know I've had a lot of chances. I'm just asking you, please, this one time, just give me one more chance. Please, Your Honor. And that's all I have to say, and thank you very much.
All right, thank you, Mr. Page. Ms. Goodrich, recommendations from the people?
Oh, yes, Your Honor, thank you. The defendant is 31 years old. It looks like his first arrest was at 14 years old. He has 5 prior felonies, 5 prior misdemeanors. There's a public safety concern on the type of felonies on his record. Accosting a minor, breaking and entering, multiple weapon charges. He's been placed on probation 4 times, jail 5 times. He's been to prison 3 times.
At this point, the rap sheet's longer than the judge's patience. When a prosecutor starts reading like a resume of bad decisions,
some of the relevant factors
you know where this is heading.
Services have been provided prior to this. He was on parole when he committed this offense. It looks like from the PSI that he has a history of MDOC misconducts, approximately 24 total. He initially was on parole on August 1st of 2023. It looks like in June 29th of 2024, he operated a vehicle under the influence, also had drug paraphernalia and weapons. On November 14th of 2024, he was on parole and was reinstated with a scram. On June 17th of 2025, while on parole, defendant operated a vehicle with an expired registration plate. He refused the PBT. He had empty whiskey bottles, multiple, found in his car. The cup next to him had alcohol in it. The lab blood result came back at a 0.195. He completed a substance abuse assessment back on January 3rd of 2024, but did not follow through on any of the recommendations. His guidelines are 10 to 28 months. The PSI, I believe, appropriately recommends the 28 months to 70 or 6 months. The top of the guidelines is appropriate in this case based on his decisions in his past. When he's released from this prison term on parole this next time, I hope he does use that support system that he has available and takes advantage of having that benefit, as well as the substance abuse services in our community. Thank you.
All right, thank you. Mr. Page, if you please stand for the first sentence. There are, yeah, I know Mr. Page has acknowledged his prior record not being his best foot forward, so to speak. It is important that on the record we place some of those things. So some of the relevant factors that I've looked at here, back in November of 2014, Mr. Page was sentenced for a felony breaking and entering. He got probation with 6 months upfront jail and the SAI boot camp. And then in 2015, he violated probation by drunk driving with a high BAC. He got 6 months more in jail, but probation was continued. So he got chances to address that, 10 years ago. In 2017, he violated that probation again by stealing a gun. He went to prison for that, for 28 months on stealing the gun and 4 years on the probation violation. While he was in prison in 2018, he committed another felony by possessing a weapon in prison. He got another 14 months in prison for that. Then while he's still in prison in 2020, he commits another felony, prisoner possessing contraband, and he got another 14 months consecutive prison for that. So that's why then the prosecutor says went to prison 3 times. It was really 1 time he went, but you had 3 commitments, 3 sentences. So that's when he did the 6 years, and it's, reported in the PSI and also in the defense sentencing memoranda that, you had some really negative experience that had happened to you or around you while in prison. And, that's regrettable and that should not happen. That's not what anybody intends to happen. That's not part of the punishment of a sentence. Prison should be a safe environment for people, but the reality of human behavior makes it such that sometimes it's not. So I regret that you had to witness some of those things. You were granted parole on August 1st of 2023. The next summer, July of 2024, you were arrested for drunk driving on parole and a CCW, a carry concealed weapon charge. In that case, there was a BOL, be on the lookout for someone driving crazy. You were twice the legal limit, had a fixed blade knife in the visor of the car. That November, I dismissed the CCW charge, finding that there was not legal basis for that charge. But it did qualify as a violation of parole, possessing any weapon at all. But I dismissed that felony charge and granted you a PR bond. And then the DOC lifted the parole hold and reinstated your parole. Again, giving you chances to address these issues. You responded by tampering with your alcohol scram tether in early December. And then in December, I sentenced you. You pled and were sentenced to the misdemeanor OWI. You'd already served the maximum time, so we cut you loose at that time. And your parole was reinstated, continued. And then this May, while you were still on that parole, you were again arrested for a OWI 0.19 BAC. In addition to the 2 felonies committed while Mr. Page was in prison, he had several misconducts in prison, including using alcohol 3 times, using other substances 3 times, fighting 3 times, possessing stolen property 3 times. So, you know, you were kind of contributing to some of the bad environments and behaviors in prison as well. There's a pattern of drunk driving here in 2015, 2024.
This is the breaking point. The judge isn't just sentencing Page. He's calling out the entire parole system. This moment isn't about one man's mistakes. It's about the system's failure to protect the public.
In 2025, there's a pattern of drunk driving here in 2015 involved 2024 BAC of more than twice the legal limit. All 3 of those drunk drivings involved while Mr. Page was on some form of supervision, legal limit, probation, parole. All 3 of those were committed while Mr. Page was on some form of supervision, OWI committed parole on the same term of parole. And this is the second OWI committed all of this on the same term. And Mr. Page says that now in May, since May of 2025, well, and Mr. Page says that now in May, there's been more than May of 2025 and opportunities for you to get sober. He wants to get you drank and used in prison. I mean, there's been more than a decade. You drove drunk while on opportunities. You drove drunk while on parole. Instead, you drank and used in prison. I mean, you drove drunk while on probation. What you're telling me today is true. But how on earth can I accept that as true? I hope and wish what you're telling me today is true. How could you reasonably expect the judge to say, "Oh, now Mr. Page says he gets it"? I mean, how could you reasonably expect the judge to say, "Oh, now Mr. Page says he gets it"? And that is just not how it does. It's just not, there are ways that this works. I've received a copy of a Parole Board decision how it does, dated September 24th of this year. I've received a copy of a parole board they intend to reinstate dated September 24th of this year, and they find, quote, reasonable assurance reinstate your parole this November, that the offender will not become a menace to society or to public safety. Reasonable assurance exists. I mean, I don't want to stray too far out. Become a menace to society or to the public safety. Come on. I mean, I don't want to disagree anymore with that statement. Parole process. I think it makes a mockery of the criminal justice system. I could not disagree. I don't even know with that statement. Words in the English language makes a mockery of the criminal justice system. If you can say, I don't even know about what this offender at this English language mean. Reasonable assurance. If you can say that Mr. Page will not be a menace to society at this time. Safety. How about he drives drunk whether he's on probation or parole? Mr. Page will not be a menace to society. How about he commits felony crimes even while he's in prison? How about he drives drunk whether he's on probation or parole? I'd like to know what the parole board thinks. How about he commits felony crimes even while he's in prison? I think it might be Mr. Page. I'd like to know what the parole board thinks is a menace to society. And all of that doesn't. I think it might be Mr. Page that he's a registered sex offender. And all of that doesn't even take into account that I think the advisory guidelines of 10 to 28 months do not adequately take into account 3 factors. I have to say, I think the advisory guidelines of 10 to 28 months do not adequately take into account 3 factors, even while in custody.
In State v. Michael Page, a 31-year-old habitual offender and registered sex offender. The court reviewed his 6th felony drunk driving, a 31-year-old habitual offender and registered sex offender. Despite multiple prior convictions for felony drunk driving with a 0.195 back for rehabilitation, despite multiple prior convictions for sobriety efforts, burglary, the judge rejected Page pleaded for rehabilitation parole board's plan to reinstate him a sobriety efforts. The judge, citing his decade-long pattern of crimes under supervision, to reinstate him a mockery of justice. The court issued an upward departure sentence of 5 to 7.5 years in prison, emphasizing public safety. To make better choices behind bars. Upward departure sentence of 5 to 7.5 years in prison, warning Page to make better choices behind bars.
In custody more than twice the legal limit every time he drives drunk, even while under supervision. Second, defendant's pattern of driving at more than twice the legal limit every time he drives drunk, even while under supervision. August of 2023. And third, the Michigan Department of Corrections doesn't believe that behavior is enough to return him to prison on his parole. Yet the Michigan Department of Corrections doesn't believe that behavior is enough to return him to prison on his parole. Guidelines is warranted in this case. Given that honestly, I think defendant's departure from the guidelines is warranted.
5 to 7.5 years. Firm but fair. After years of second chances, the court finally closes the door. What do you think? Redemption denied or justice finally served?
Warranted in this case. You know, I regret, Mr. Page, to tell you, I think the maximum sentence is disproportionate here. His third drunk driving, the law limits what I continues to possess weapons inside prison, and which means the highest sentence that I can impose, even though I dismissed the charge, he was possessing weapons 90 months in prison. or 5
It's clear
years
that
to
this
7.5
defendant
poses a
years.
danger to society.
I believe, given the history I've outlined, given his behavior,
I regret,
while on
Mr.
parole,
Page, to tell you, I
his
think over the
behavior
last
maximal
2 years
sentence while
is
on parole in our
proportionate
community.
here.
Last
The
year.
law limits what I can do.
I believe that a minimum term of 5 years in
maximum,
prison is
which
certainly
means the highest sentence given the
that I can
seriousness of the
impose
circumstances
would
of
be
both this
60 to
offense
90
and this
months in
offender.
prison. Such a
5
sentence, I
years to
believe, to be
7.5
more
years.
proportionate than a sentence within
I
the
believe, given
advisory
the history I've
guidelines
outlined,
range.
given his behavior while on parole,
Therefore,
his
Mr. Page,
behavior
I
in
am
the
going
last
to
2 years
the
while on
Michigan
parole in
Department
our
of Corrections
community
for not less than 5 years.
last year,
nor more than 7.5 years.
I believe that a
exercising my
minimum
discretion
term of
under the
5 years in
habitual offender
prison is
statute
certainly
to
a
increase the
proportionate
statutory
sentence given the
maximum.
seriousness of the
That's
circumstances of both
mandatory
this offense
consecutive
and
to
this
parole,
offender.
so there's no
Such a sentence,
jail
I
credit
believe,
given
to
because
be more
you've been on parole
proportionate than a
payment.
sentence within the advisory guidelines range.
There's $68 in state cost,
Therefore, Mr.
$130
Page, I
in
am
crime
going to
victims
make the
assessment,
Michigan Department of
$350
Corrections for not
in
less
court
than
costs,
5
and a
years,
$200
nor
OWI
more than
reimbursement.
7.5 years,
Exercising
you
my
can-
discretion under the
and,
habitual offender statute.
from what I
to
outlined
increase the
about what
statutory
happens in
maximum.
prison, what you've seen, what
It's
you've done,
mandatory consecutive.
there are
to parole,
choices
so
you
there's
can make
no
in prison
jail
too.
credit given because you've been on a parole detainer.
And you can begin to address
There's
these
$68
issues
in
in
state
prison,
cost,
and I hope you make
$130
better
in crime
choices on
victims
the inside
assessment,
this time.
$350 in
parole,
court
you're
costs,
still
and a
going to be
$200
paroled as
OWI
a fairly young
reimbursement.
man. You'll still
you
have
can-
choices to make
and,
when you're
you know,
paroled next. From what I outlined about
So
what happens
I
in prison,
hope that
what you've seen,
half
what
of
you've
what you're
done,
telling me today is
there are
true.
choices you can
and
make
that
in
you'll-
prison
You'll
too.
be on a better path, and this will be the last.
And you
get
can
to prison.
begin to address.
But I
these
think,
issues
given
in
that
prison,
history,
and I hope you
should
make better
expect
choices on the
judges to
inside
give you
this
the
time.
maximum that they
And when
can.
you are paroled, you're still going to be paroled as
I
a
think that's just
fairly
what's
young man.
reasonable.
You'll still have choices
Mr.
to
Page,
make
if
when
you
you're
want
paroled
to
next.
appeal,
You can do so by
So
filing an
I
application to the
hope
Court of
that
Appeals.
half
If you
of
want
what
a
you're
lawyer,
telling
I
me
will
today
give
is
you one.
true.
You'd have to ask me
And
in
that
6
6
months.
you'll
We're
be
going to
on a
hand
better
up these
path,
papers
and
explaining
the
that.
last can
Ask you to
do the
initial
prison
them.
for us. The other one's for the fill.
But I think given that history,
good luck.
you should expect judges to give you